Now, it was a great pleasure to listen this morning already to Claire's introduction, because the amount of factual background she could give and legal background was quite impressive. So I can just go on and add on that. But of course, when we talk about the consequences of the Schrems versus DPC case for today, we have to, I think at least, we have to take this one little step back and think about the reality of what's going on. The David against Goliath idea of this is not just a little word game. It's really, we have one citizen, Max Schrems, who as a young guy went along and tried to make this idea of Europe of rights a reality. And it's one of these type of activists, we have far too few of those in Europe. If you followed, like me, Max Schrems' approach over the years of trying to get a national data protection authority to actually investigate some things, of trying to find legal support as a single citizen of any law firm to do something with him and to support him, virtually impossible. And so Max Schrems, with his energy he brought to this, is a positive example, but also shows very, very strongly how difficult it is. Because Max Schrems is not the only one. There are other citizens who tried things in Ireland and elsewhere. And the amount of personal financial risks people have to take on to try to enforce these rights is quite considerable. There's a very sad case of another Irish complainant who ruined himself in court with the high legal fees there are in order to bring rights out. So the background is quite simple. Max Schrems went along after the Snowden revelations. He had been on the issue quite a long time, having then public acknowledgement of the legal situation as it is, and the long debate that actually, and the long criticism, many years before Snowden revelations already, the debate was quite strong, that the safe harbor decision of the European Commission of 2000 is essentially giving the US a very, very advantageous deal. There is nothing adequate about the treatment in the US by comparison to European levels, and the pure business needs played their role. And it was very difficult to get DPA's, data protection authorities, independent data protection authorities, to look into this because of the very uncertain legal situation between one side, a commission decision, and the other side, data protection authorities' obligations to investigate. And that was exactly when Max Schrems went to the Irish Data Protection Authority and said, you need to investigate Facebook's transfer of data to the US because the Facebook company has openly admitted now to have been part of the PRISM program. The Data Protection Authority in Ireland said, no, we can't do anything. Your complaint is inadmissible because of the existing decision by the European Commission, of which we are bound, so therefore we will not treat your complaint any further. There was, some of you will know, a parallel complaint before the Luxembourgish Data Protection Commissioner. And the Luxembourgish Data Protection Commissioner actually went further. They actually went and investigated. But, and if you read their decision, it's openly available. You know, ever since Skype was bought by Microsoft, data flew to the US, were transferred to the US to be processed there. The data protection authorities of Luxembourg could go to Skype offices and ask Skype/Microsoft, did you do anything wrong? And they said, we didn't do anything wrong in Luxembourg. And since the territorial reach of the Luxembourgish Data Protection Authority is the territory of Luxembourg, that's where they had to stop. The problem that with the transfer of data to the United States, the issues were actually taking place in the United States. And Microsoft was under the obligation, under the gag orders which were already mentioned, not even to admit to the public that they were actively taking part in these programs, led to the fact that they were obliged also to lie in Luxembourg. But if you so wish, it wasn't even a lie when they said in Luxembourg we didn't do anything wrong. Okay, so that's just a few words to the background and to the necessity. And it also comes, of course, to tell us something about the difficulty of our data protection system in Europe, where we have national data protection authorities in charge of investigating with all these problems. Independence sounds great. They are independent. But some are so independent that they are afraid of actually taking a decision, simply because they risk being taken to court for damages if their decision is overturned. So if they would stop transfer of data for non-adequacy, they get taken to court for damages payments. Many of the data protection authorities in Europe are so independent that they have to pay those damages out of their own budget, and they won't be able to hire people anymore. The other part of it is data protection authorities are, like any agency, subject to regulatory capture, which means, obviously, there is industry interest, and given the fact that we in Europe have 28 national data protection authorities plus the regional ones, so 40 or so data protection authorities which deserve the name under Article 8, Paragraph 3 of the Charter of Fundamental Rights, these data protection authorities obviously in some cases have regional economic interest also in the background and in the political context in which they act. And for some states, for some regions, it's a question also of economic, part of the economic policy of the region, of the state, to make sure that there is a business-friendly environment, as we could call it, which allows then for weaker enforcement. Now, the Court of Justice case came in this context, right? All of these factors which play a role, and was remarkable. Remarkable for 2 reasons, or actually for 4 reasons, or for 5, whichever you want, but remarkable in any case. The first reason it's remarkable for is because it will be remembered totally irrespective of the data protection dimension. The case will be remembered for its fundamental rights dimension, because it's the first case ever the Court of Justice of the European Union has declared that the essential elements of fundamental rights had been violated. So the hard core of protection of rights, where you don't even have to look into proportionality of limitation anymore. The very right has been taken away if the essential element of a right has been attacked. And the court found that in Schrems. The Commission Safe Harbour decision, which had declared data protection level in the US for all those companies who had self-declared under the Safe Harbour regime to be adequate in the sense of Article 25, had violated the essence not only of the substantive right to protection of personal data, Article 7 and 8 of the Charter of Fundamental Rights, but also to the procedural right of the right to an effective judicial remedy, which is, in its dimension, actually at the same level, because it's this horizontal right and will be regarded to the future. Okay, but there are, of course, other consequences. The future of the internet. Member states' laws on secret surveillance and national security, as well as, of course, the future of transatlantic relations and approaches. Let me go through some of those elements in order simply to add on to what has been said earlier. Now, the future of the internet, as we know it, of course, is that in questioning the legality of the Safe Harbour Agreement with the US, we're talking about the backbone of the internet, the transatlantic data flow. Huge amounts of data flow on the transatlantic basis, not only because US companies, big US companies, have such a strong position on the market. Think of Facebook, think of Google, think of Apple and Microsoft and the likes of them, but also simply because we have 500 million fairly wealthy citizens in Europe, a huge market in Europe, and no area in the world can circumvent and live without access to the European market, which I'll come back to later is actually our greatest strength in this question. So the question of the future of the internet is in that sense asked because what actually happens after Schrems? We were discussing that a little bit earlier. Does it mean that data protection authorities now, in enforcement of this ruling, have to stop data flow between Europe and the United States until a new data agreement, adequacy decision of some kind have been found? Now, the Court of Justice gives us several answers to that. The first is, And that was in immediate response to the High Court of Ireland's question, because essentially the initial case was the Irish Data Protection Authority said, we won't investigate your complaint, Max Schrems, because there's the safe harbor decision. So the very initial question was only, and this is the wild thing about the case, we're only talking about the very first step. Does the National Data Protection Authority have to investigate? And the Court of Justice says very clearly, yes. National data protection authorities have to investigate according to the standard of the duty of care set up under European law. That means they have to have a full and impartial assessment of all relevant facts. Now, as I was already mentioning, that is difficult for national data protection authorities because they have territorial jurisdiction. Yet, actually, the Court of Justice asks each one of the national data protection authorities to look into foreign law, in this case US law, which isn't easy, as we know. We were just told that. US law is not like one homogeneous block. We have federal level, the state level. We have an incredible amount of national security legislation which references and cross-references. We have the US style of legislation, which is extremely long. Think of the FISA Act. You know, we're talking about section 1800 something of the FISA Act for a specific provision of access. In Europe, we're not used to such incredibly lengthy legislation, which, you know, detailed into all levels. And when we take on that level, not as the federal level, but the national, the state level, also the clearly legislative acts, but to try to assess what does it actually mean if, as was talked earlier by Laurent, that we have a presidential order. What is the quality, the legal quality of a presidential order? Do the authorities in the US have to comply with it? Do only federal authorities have to comply with it? Can that be revoked at any moment? Or can there be an official presidential order with all kinds of secret sub-orders? Totally possible. Given the history of the US law with these gag orders, I would say we have to assume that there are many more levels of presidential orders than those which are published. And that would be totally fine, of course, within in an authority, in a system like the US, where you have a unitary administration headed by the president, but then, of course, parallel state authorities. So, all of that means, under which conditions can we have ever an assessment of an adequacy? What are the criteria? The criteria were already discussed. The criteria are essentially fundamental rights protection as it is required under the European legal order. And that word European legal order is interesting in that context, and it's going to be very interesting with respect to the future Article 29 Working Party decisions and with respect to the future European Commission approaches. Because European legal order means what it says, not just the European Union's law, but the European legal order. And that, you know, ladies and gentlemen, we see the lobbying machine revving up, obviously. You might have seen the Financial Times has published an opinion by a barrister from London who, you know, that is rather laughable piece of work. It argues that privacy protection has no history in Europe. It only actually stems from the United States, therefore we should trust the United States. I do not want to diminish the intense debate in the United States about privacy. I think that's very valuable, but it's historically flawed, of course. Legislation in Europe since Enlightenment goes far back. There's even a case where a French postman was given a death penalty in the 19th century for accessing secrecy of communication. So these kind of arguments look in Europe, we're miles behind the US. The US has developed this, and therefore just trust the Americans, they'll do it. I don't buy that. Key for our adequacy decision is the fundamental rights level as it is protected by the European legal order, which means the Charter of Fundamental Rights for the European Union and the European Convention for Human Rights for all national activity which does not fall under union competence. So what falls under union competence? Under union competence falls explicitly action by EU institutions and transfer of data to third countries, which means third countries and their adequacy will be measured against EU standards. What does not fall under EU competence is national security. National security, however, is reviewed under standards of the European Court of Human Rights, by the European Convention of Human Rights, by the Court of Human Rights. What was already mentioned is the case Sakharov against Russia. So, in December, a couple of weeks after Schrems was published, Schrems being decided by the Grand Chamber of the Court of Justice with the President and the Vice President of the Court, so a very strong and very important statement. The Sakharov case being decided also by the Grand Chamber of the European Court of Human Rights with the President unanimously, finding that, it's essentially a case about proof, finding that Russian legislation, which requires that an individual who wants to complain against the mass access to his data and undifferentiated access, because under this Russian legislation, you didn't need to be a suspect for your telephone communications to be accessed, that you could only have standing in court if you proved that the Secret Services would get your data. And the Court of Human Rights said, like, that's a joke. I'm sorry, I'm simplifying, of course, because if the nature of the data collection is secret, sorry. If the nature of the data collection is secret, you can't request an individual to have to prove that your data has been collected, because you can't prove something which is secret. And that's exactly what we're looking at in American law. Even if under the FISA court, ex parte court where you can't actually have standing as an individual, even if standing would be opened, if still the rules of proof would be you have to prove that your data has been accessed, but companies have to keep secret about giving the data to the authorities, then that would not fly. So, Sakharov, very interesting, just on that level. A couple of days ago, January 12th, Harbour and Visi against Hungary. Even more explicit, because that case of the Court of Human Rights refers twice explicitly to the Schrems case, therefore says, look, the ECHR, the European Court of Human Rights, accepts and interprets the European Convention of Human Rights level of data protection in the same way as the Court of Justice had in Schrems. And by the way, the Court of Justice in Schrems heard many arguments, obviously, about European Convention levels. So, Harbour against Hungary is interesting because that is the first case with an EU member state involved. So the Hungarian legislation, which was declared to be in violation of the rights to privacy, provided for many of those elements which we were discussing. And that means that much of the national legislation in countries which have gone very far, like the recent French legislation, is and will be put to the test before the European Court of Human Rights. And with Harbour against Hungary, we have the standards by the Court of Human Rights. Which means in the inverse, the argument saying, the lobbyist argument in saying, well, look, there are various member states in the European Union who don't protect the rights more than the Americans. Actually, the American protection is slightly elevated vis-a-vis some of the member states, is like, I drive here to Brussels, the police stops me, and I say to the policeman, yes, I've been speeding, but other people have also been speeding on the motorway, so therefore you can't find me. Obviously, that doesn't work. The standards are the same, and the standards have to be complied with by the member states as well as by third countries. So, what the court also clearly in Schrems requires is not just adequacy according to the levels of European fundamental rights standards, and that's also the important part of Schrems, to re-insist on that, but to make sure that this is not just in theory and law in the books, but in practice. And here, of course, this becomes very, very difficult for the data protection authorities, for the Working Party, the Article 29 Working Party, for the European Commission, to actually make sure that that is something they can look at. Because if you look at the data, the adequacy decisions which exist, they exist with countries so far which have data protection legislation. But it's very difficult to say how far that data protection legislation is actually complied with, or whether there's other legislation on the books which allows through the back door of Secret Services or others to access. So it's a tricky business all around, and I think that's been acknowledged and accepted. But does that mean that we should lower our standards just because there are factual difficulties of fact-finding? No, the standards cannot be other than those established by the Charter of Fundamental Rights and the European Convention of Human Rights. Now, what are we then looking at of the transatlantic relations? Transatlantic relations, obviously hugely important, economically and other. There are negotiations for the TTIP, for TISA, for other agreements. There have been attempts to write into TTIP, for example, a norm that nothing should stop data transfer in order to circumvent these kind of problems. That, of course, would not stand judicial review in light of Schrems, so that's a no-starter. We will have a lot of questions going on with regard to new US legislation. What was already mentioned is actually one of the, which gave me lots of pleasure personally seeing, that one of the effects of the Schrems case was massive lobbying of US data companies vis-a-vis the US government to get legislation going. So the Judicial Redress Act, which is currently debated in the Senate, the US Senate, which would address some, by far not all, but some elements of the problem, is obviously has been speeded up due to this lobbying effort, and that was very positive. But of course, the question is, can we really address these various problems, especially the problem of the interaction between private parties and national security authorities and the powers given them? Now, what possibilities are there? Already the possibilities for the data protection authorities were discussed earlier in the earlier session. So the standard terms of contract, the binding corporate rules, which face exactly the same problems as Safe Harbour did, because obviously Safe Harbour was nothing but a self-declaration by a company to follow certain rules. You know, binding corporate rules or standard contract clauses do the same. Companies say, we will follow certain rules, but obviously a third country's security legislation, public law of the US, for example, can overrule such contract clauses or such self-declarations. That's the very nature of public law. So therefore, that can't really help. Encryption, well, it's a problem with the keys. Who has the keys? Where are the keys? Will it do practically? Microsoft has found a solution to it. They say, well, we'll try to store data in the European Union. They offer some data storage in Germany. And there's a case pending, you might have heard of it, which will go up to the Supreme Court in the United States, of access to emails stored by Microsoft in Europe, in Ireland in that case. And the opinion of one side is, well, look, Microsoft is a US company, so therefore subject to jurisdiction under the US, and therefore has to produce the emails in a US court. And the other side of the argument is, no, the emails are stored in a foreign jurisdiction, and therefore they cannot be requested by US authorities to be produced in the US. It's an essential question. Google claims to have done things differently. They claim to store their data on all of their computers. They use their worldwide data centers like one big hard drive and store bits and pieces everywhere. So they claim they can't say where their data is actually stored. But that can be used against them, of course, because of course Google can get their data if they want to. So therefore, actually every jurisdiction could say, you give us the data because it's somehow also here. So it's practically extremely difficult. What can we do? What can we do? Well, I think we have to simply go back to basics. Maybe it's the lawyerly answer, develop solutions from basic principles. The basic principle has to be the protection of rights. After all, the Court of Justice starts in Schrems, its declaration, with saying, this is a union based on the rule of law, and therefore those are the consequences we have to draw. And that comes back to what I was saying earlier. Europe, we should not hide ourselves. We have a very weak enforcement system with a 29 versus 29 working group representing the 40 independent data protection authorities, with the risk of regulatory capture and splitting up of them. But if you think about it, Europe is an indispensable market, not just for American companies, but also for Indian companies, for Chinese companies, and so on. So let's do what we like to do in many cases, which would also from a purely utilitarian point of view would be good for Europe, which is set the standards high and make sure that they are complied with. By that, we'll have the effect of an export of European standards, the Brussels effect as often discussed. We'll have the effect of protection of rights, and as long as others do not comply with our standards, they will not have access to our markets. So, in that time, European business can profit from that time. In other times, as soon as others comply with our high standards, we will have exported high levels of protection, which is good, and then advance also with this international exchange. I think that, at the end of the day, is the only principled approach we could take. But, of course, that does not come for free, because the amount of companies which are affected is quite considerable. We're not just talking about Facebook and Google and Apple. We're talking about any company, a bank, an insurance, any hospital which transfers its hospital letters to be dictated, to be written up in a different jurisdiction, or things like that. We're talking about this data transfer of any company which sends out a worker maybe to maintain a machine which they have implanted somewhere. You know, when you send someone abroad, you have to actually usually send some data about this person also abroad. The effect goes throughout the economy. That is the worry about the legal uncertainty, but that is also the strength of the effect of saying, let's have a principled approach, high level of protection, will do not only ourselves a favor, but pretty much everyone else also. Thank you.